Good afternoon, everyone. Thank you for joining us today. I hope you're all enjoying this beautiful day. At least it's beautiful in Albany. I'll just take a few minutes to go over some housekeeping items, which at this point I'm sure you all know. You do have to be on this webinar for 50 minutes, 50, in order for it to be counted for CEU. If at any point you get kicked off or your webinar drops, please contact us immediately. You can just send us an email, hey, I got kicked off, I'm getting back on, but it really helps in the end when we're trying to match our records. If you have any questions at all during this webinar, please type them in the question box. Jen will be answering them as we go through. I'd like to welcome our presenter today. Jen Graziano is an attorney and a fourth-generation licensed funeral director in both New York and Connecticut. She's the host of Time to Talk with Jen Graziano, a weekly radio program on WVOX and podcast that draws attention to sensitive matters and important topics surrounding aging, planning, health, and wellness. Her passion for aging issues continues with Coming of Age magazine, a quarterly publication that further discusses these topics. Jen is the co-owner and operator, alongside her father and brother, of 3 funeral homes. She is passionate about bringing awareness to the funeral industry, along with developing ways to help protect its future. She is the founder of Remember, a collection of fine memorial jewelry that she is proud to have displayed in many funeral homes. Her greatest title is mom to her 11-year-old daughter. Welcome, Jen.
Hi, thank you so much, Kelly, and good afternoon, everyone. So happy to be here with you today. And as Kelly mentioned, I am truly passionate about protecting our industry. I am your colleague. I share the concerns, the frustrations, and also the joys and rewards that all of you share. So I'm delighted to be, although I'm on this side of the panel today, I am certainly with you guys for every part of this lecture. What I did hope to do today, like Kelly mentioned, you can stop and ask a question at any point during the presentation. I know one of the side effects of spending your life in a funeral home are memory issues, short-term memory loss. So I'd rather you ask the question, and if it's something that's more involved, I'll be happy to get your information and get back to you privately. But thank you for the opportunity, Mike and Kelly. So let us begin. So today we are talking about protecting your funeral home from liability. And a bit about me, as Kelly mentioned, I'm a fourth-generation funeral director, now overseeing operation of our 4 funeral homes. A quick picture of my dad and brother right there. Extremely proud to carry my father's legacy forward into this next generation. I am an attorney of counsel with Ferguson and Cohen, so they specialize in elder law and trust and estates issues. I'm the host of Time to Talk, which is now a podcast that can be found on Google, Spotify, Apple, wherever you hear your podcast, and a great advertising vehicle for the funeral home, and the founder of Remember. But yes, my greatest title is Mother of Mia. So what are we discussing today? We're discussing protecting funeral homes. And today's presentation came out of a discussion that I had with Mike Linati, Bill Villanova, where I was sharing frustrations that we are really an overexposed and underprotected industry. Now, full disclaimer, what we're going to look at today are potential claims that can arise in the course of doing business. Nothing I will present to you today will make your funeral home lawsuit proof. A family that wants to sue you will do just that. But today we're going to look at what they can sue you for, why they can do it, and how we can be mindful and aware in our daily practices and mitigate the potential liabilities that we are exposed to. We really want to arm ourselves with the knowledge needed to help our businesses run smoothly. I always say, no one turns the key in the door every day with the intent to hurt a grieving family or the intent not to do the right thing. I'm optimistic in that sense. I think we're all well-intentioned. And I also believe that no one understands the unique pressures and challenges that face this industry. But nonetheless, we have to face them ourselves head on and be prepared to defend ourselves and our businesses. So let's begin. Okay, so today we live in a litigious society. We know that. It's easy to make claims. There are attorney advertisements that, run across the internet, TV, podcasts, everywhere. It's very easy. If you want to make a claim, it's very easy to make that claim. We're also going to acknowledge that there's a lot of industry misconceptions about us. There's a never really terrific media portrayal of the industry, and there's always that, notion that we are dealing with a vulnerable consumer and we are, the big bad funeral director that looks to prey on that or take advantage of. So we keep all of these things in mind when we think about how easy it is for lawsuits to arise. We're going to talk about COVID as well and this great misconception of how we all profited, which I put in quotes for a reason that I'm sure all of you would concur with. No one understands the mental and emotional strain that COVID took on the funeral industry and the funeral directors individually and collectively. But that comes into play now, too, when we talk about potential suits and potential liabilities that are faced in the industry. We're easy targets for sure, ladies and gentlemen. And today we hope that you learned something from this. And again, you can arm yourself and protect your business and keep things running efficiently. So our focus is to make funeral firms aware of potential claims that can arise from dealing with our client families and to mitigate potential liability exposure in our day-to-day business practices. Let's begin with looking at potential areas of liability. Now, some of these, right off the bat, they're going to jump out of this. Of course, it makes sense. I mean, certain things, if you do the wrong thing, you're going to get in trouble. So let's go through them, and then we'll break them down a bit further. Potential areas of liability: improper embalming or improper storage of a body. Stolen organs for purposes of resale, not touching that one, but falls under the category for sure. Commingling of ashes. Again, these are day-to-day practices. Cremation is on the rise for all of us. Families want the ashes split, and some families also want, mom and dad put back together. We also have unethical treatment of the deceased. These are vague areas, but again, they can get couched into very specific claims against us. Loss of cremated remains, theft of personal property. Think about it. How many times do we get told, well, mom came in with a necklace? These are things that we hear every day. Burial in the wrong grave site. You could be in the right plot, wrong grave. Deceptive sales practices. Again, a very broad brush here, but this could be something as simple as failure to disclose to a family all casket options, or they have casket A on a prearrangement, and then when it becomes an at-need, they get, casket B, casket A's closest cousin. Continuing down our list, again, substituting a casket from what a family selected. Failure to deliver a monument by a promised date. Again, we know we all deal with monument companies. Those target dates, they're often not correct. So we have to be mindful of even something like this when we're dealing with third parties and introducing third parties to our families. We can have liability exposure as well. Dropping the casketed remains of a deceased. Burying the incorrect deceased, not adhering to GPL charges. There are so many more areas, but these are just a good list of some ways that we can be exposed to liability. So now, those are the areas of liability. Let's break it down legally to what legal claims do these fall under. And we'll continue to break down further, but there's a bit of a legal education here for us today. The potential legal claims that we can face as funeral homes and funeral directors are intentional infliction of emotional distress, negligent infliction of emotional distress, loss of sepulcher, that's a big one that many of us may not have heard of, fraud, breach of contract, negligence, or theft. So we'll break down what those mean piece by piece. But those are the types of lawsuits that we can be met with by a family. So, what are the potential damages that can be awarded in New York? What can these families get? Well, they can get actual damages. Actual damages are just that. Actually, whatever the loss was, their actual damages, however that can be calculated, they can receive that as a compensation. Lost wages, for example, if any of their dealings with us or the breach or negligence that may have happened, if it caused them to lose time at work, they can get lost wages. Emotional distress, this is a big one. We're going to break that down fully today. And emotional distress, how it's proved, so we'll get into that. But that is a potential damage that can be awarded in New York. Medical bills, this goes into actual damages, any medical harm that was suffered, any resulting medical bills, doctor's bills, hospitalization, a family can reclaim that. And then punitive damages, and that's in excess. Punitive damages are exactly as they sound. They're punitive. They're in excess of any measurable damage that a family incurred. This goes above and beyond and seeks to punish the defendant for wrongdoing. So let's go through what are the basic elements of a negligence claim. Well, first, there is a duty of care owed from one party to another. So let's look at contractually what it looks like when we're meeting with the client's family. John Doe's family calls X funeral home. There's a duty of care owed. The funeral home has a duty of care towards the client family and to the decedent as well. These are two claims, and keep that in mind because a family can sue on behalf of mistreatment of the deceased, and they can also sue for the emotional distress that they incur through their dealings with the funeral home. So there's a duty of care owed. Number two, there is a breach of that duty. The funeral home director breaches the duty by acting negligently or failing to meet professional and accepted standards. There's causation. This breach of duty causes an emotional harm to a family. And then there are damages. The family suffered emotional or financial harm for the breach. So you have those elements whenever you have a claim for negligence. Those four elements must be there. Let's talk about emotional distress in New York. There are two types of emotional distress in a New York action, one of them being negligent infliction of emotional distress. It's a very vague area. Again, a very broad brush here. There's a lot of things that can fall under negligent infliction of emotional distress. There are no statutes governing negligent infliction of emotional distress in New York. It's really a matter of case law that sets a precedent. So if these claims come in as an action, the court's going to look at similar cases and defer to the case law to find its ruling. This is an easier threshold for a plaintiff to prove. Again, the plaintiff must show that the defendant, which is the funeral home, had a duty of care. The defendant breached the duty of care. The defendant's breach caused physical harm or impacted their safety or caused emotional harm. The defendant's conduct was outrageous and extreme, and the defendant's behavior caused the plaintiff to suffer emotional distress. So again, New York it's a pro-plaintiff state in a lot of these claims. And again, going back to what I said earlier, we look at kind of the nature of the funeral business. There's a vulnerable consumer, and New York happens to be, again, that pro-plaintiff state, where they're going to look at even the facts of the case. They're going to look at the aggrieved party, the plaintiff being a grieving party, and the court does put deference on that a lot of times. So that does work in the plaintiff's favor. As I said, it's a very easy threshold for a plaintiff to prove. They really only have to start out by showing the duty of care that was owed and that the defendant's funeral home failed to provide such. Intentional infliction of emotional distress is the second type of emotional distress claim. This one's a little different. It's known as the cause of action that shocks the system. The defendant funeral home would have to display actions that are so repugnant, the conduct has to be so shocking. There are statutory guidelines here that the court follows, so they're not just looking at past case law. There's actually laws on the books that govern this. But the plaintiff has to show, again, the defendant's actions were intentional. They were done with disregard for the high risk of the emotionally debilitating distress their actions can cause. So even if a defendant doesn't set out, a funeral home doesn't set out to do anything intentionally, if the action is so egregious, so repugnant, so shocking, the court's going to ascribe that intentional aspect to the case. So you show that the defendant's actions were done with that high risk of causing distress. You show the causation, which is the cause and effect. You have to prove actual debilitating and harmful emotional distress. And New York includes recklessness in this statute, again, meaning that the intent doesn't have to be there if this action is so shocking and so repugnant. This is definitely the more egregious one, folks. What would fall under this? The body part scandal. Cremating the wrong deceased would fall here as well. But the bottom line is the action of the funeral home has to be so above and beyond reproach, so above and beyond what is acceptable. So you see the distinction between negligent infliction of emotional distress and intentional infliction of emotional distress.
Jen, we do have one question if you want to address that now.
Sure, go right ahead.
What is the statute of limitations on intentional infliction of emotional distress? Like, how many years ago could the funeral have been?
So it depends on two things. In New York, the statute of limitation for tort liability is 3 years, but on contracts, it's 6 years. So if you contract with a funeral home, you're in a contractual relationship with them. That is the 6-year threshold. But for tort actions in New York, it is 3 years. So depending on how the claim is couched, it could probably fall on one of the two, or what claim we're looking under. But for tort liability, you are looking at a 3-year window in New York State. Anything else,
Great.
Kelly?
Thank you. Yep. No,
okay.
She said
Right.
Thank you, so thank you.
You are welcome. So moving on, loss of sepulcher. So this is one, many of you may not have heard this one, but it has been around for a very long time, and it's actually the basis of New York Public Health Law 4200. So it was part of the New York Common Law, which was later codified in statute, which, this is the famous, agent letter one, the 4200, and all the different parts that fall under that law. This is, pretty much at any point where we're dealing with funeral home negligence, funeral home liability, this could pop up. So in New York, there's a property right to a decedent. So they treat that the next of kin has a property right vested in their deceased loved one. Loss of sepulcher basically discusses the right to choose and control the burial or cremation of the deceased. The next of kin, this is a vested right in the next of kin. They have a right to a timely disposition, a smooth disposition. They have a right to control all the aspects of a funeral arrangement, and anything that's done to impede that right can fall under loss of sepulcher. And we're going to look at it. I'm going to show you some examples and some case law. This is something that expands beyond us. This is something that could also get into medical examiners, when an autopsy was performed without the requisite consent. This could even fall under the eye bank, the organ donation organizations. Could even fall in, there's a cemetery case that I'll show you here when the grave wasn't dug properly to allow for a casket size. Again, it's another broad brush claim. But, if you Google funeral home liability, funeral home negligence, this is something that's going to pop up. And following the presentation today, I encourage you to do that because you're going to see, the types of claims that are out there and the ways that attorneys entice families to contact them and to make these claims. But going back to loss of sepulcher, it has been around for centuries. When this right is interfered with in New York recognizes this as negligent infliction of emotional distress. So you could be sued for both the loss of sepulcher and negligent infliction of emotional distress. They often go hand in hand. So just to reiterate, it was a common law in New York, codified now in New York Public Health Law, Section 4200. Very vague interpretations of the law, but once again, it's predominantly a pro-plaintiff result. If you're looking at a grieving next of kin who had a disrupted funeral for their loved one, there's going to be a deference to the plaintiff on that. Not to say that there's no hope for us, because there is, and I'll talk about that as well. But again, we're talking about any time there's an interference with the right to a proper burial. The plaintiff needs to prove that the funeral home did not act in good faith in carrying out the disposition of the decedent. And lack of good faith is something that's important. I'll talk to you guys about it in the end. It really is, it's our go-to defense here that's available to us in New York. But again, this is a right that New York, the loss of sepulcher, the right of sepulcher is a right that New York recognizes the next of kin has as a property right over their deceased loved one. This is often the catch-all claim. Again, anything that goes wrong between the initial call and the disposition, a lawyer could often put it under this claim. And it's always, again, based on some negligent act done by the funeral home when you see a loss of sepulcher claim. Let's talk about some examples of it just so we can illustrate it and bring it to life. Okay, the first case that I outlined for you. Now I have a check and an X. I'm sure you can figure what that means, but I will, we'll explain it in further detail. On the first case, this is a New York action. It was in Bronx County. We're not going back that long ago, 2021. So the plaintiffs contended they did not authorize the funeral home to take possession of the decedent's body, nor did they authorize them to embalm the decedent. So they moved for summary judgment, and summary judgment is basically when the plaintiff's saying there's no need to go to trial. These facts are so clear, they want to make the motion that the judge rules just based on that without going to trial. So they moved for summary judgment on the issue of liability concerning the loss of sepulcher in violation of Public Health Law 4201, and for the dismissal of the defendant's defenses. Now, the defendant's defenses were a written contract that they had before taking control of the decedent's body. So perhaps the family went into the funeral home, made arrangements, and they signed off on, they initialed the permission to take the decedent from the place of death and the secondary embalming authorization. So the court denied the plaintiff's motion. There's a check here. This was a pro-funeral home decision. The court denied the motion, determining that the defendant submitted an affidavit as evidence that they had authorization. They embalmed their remains based on the accepted standards and practices in the industry, and any physical changes of the decedent's remains were due to natural changes of the remains and not improper embalming. So the claim arose that when the family was trying to bring a suit against the funeral home, they were unhappy with how the decedent looked, and they tried to go back to say, well, we never gave permission to take the deceased. We never gave permission to embalm. But the funeral home produced documentation. So what you take from this is if our I's are dotted and our T's are crossed, we can be okay. The funeral home produced the proof, the tangible, documented proof that they had authorizations to remove and that they had authorizations to embalm, and the court found in favor of the defendant funeral home. On this next one, this is the cemetery issue. Again, fairly recent, just a little over a year ago, Bronx County. The plaintiff alleged that the cemetery workers failed to dig a grave in proper dimensions to accommodate the decedent's casket. The cemetery workers tried to claim civil immunity and that they were immune from claims to the cemetery. And they said that they also try to claim that they shall not be liable for actions taken reasonably and in good faith by carrying out the directions of the funeral home. So the court found that the cemetery basically failed to prove that, they carried out written directions. They failed to justify their actions. They didn't have enough documentation to show that they were supposed to dig the grave the way that they did. The court found a loss of sepulcher for the plaintiff's family, but it came down to, again, having proper documentation, dotting I's, crossing T's. With sufficient evidence, this is a claim that certainly can be defeated in court. Again, the court found for the funeral home in the case where there were documents produced showing the funeral home followed proper protocols and completed their due diligence. So how do we protect her?
I do have a couple questions if you want to go. Okay, so first one is, can you address an itemized contract and a family not paying their bill? Contract says we are allowed to charge interest. What do you recommend for funeral homes chasing families for payment?
So that's going to come a little bit later down when we talk about those are contractual disputes. I believe the New York law on that has to be uniformity, that if you have a policy of charging interest, you have to charge that to everyone. It's not a pick and choose. Can you specifically relay that question again, Kelly? The question was, can you charge interest, or there was the before to that?
It's saying that the contract says you will charge interest, and it's just asking how to best go about chasing these families for payment.
Well, again, it all comes down to dotting I's, crossing T's. You need to have well-documented itemizations. If you have that, and I've had that in my own funeral home before, I mean, it's always a double-edged sword, because you really don't want to be the funeral home that's going after a family for payment. You don't want it to get to court. You don't want the bad press, the negative publicity, because, that you can't really put a price on what that does to you. And unfortunately, it's always that, that situation where we're the big bad funeral home going after the grieving family, when in reality we have justified charges. We've done more work than we could ever describe to them, and here we are now begging for the money. So the answer is, put the interest charge on the itemization. It has to be a fair number. It can't be a usurious number. And New York has a statutory number of what that can be. I want to say it's 1.3% or under. I can certainly find that out, get that back to you, Kelly, so you can send a follow-up. But if you put interest on one contract, you have to put them on all. If that's your policy, you have to show all families. I'm thinking about the itemization that we use, where we say the contract is due by date X. If it goes unpaid beyond date X, the funeral home has the right to charge interest of X amount per month. If that's all signed and documented, you can send that to an attorney. Depending on the value of how much they owe you, it would go into small claims court if it's under a certain number, or general civil action in Supreme Court if it's a larger number. And if the documentation is there, you can claim that money. If it's a situation where it goes into a probated estate, funeral expenses can come off the top. You can get your compensation that way. But you do have a valid right to charge it. And it is a breach of contract if you have a signature of a party and they fail to uphold their end of the contract, which is payment. You as a funeral director definitely have a cause of action for them.
Great. Thank you. And I have one other question, scenario question, if you're good with that. Okay.
Yeah.
3 times over the past 5 years, I have arrived at a parish cemetery to find that there isn't enough room to bury the person due to a previous burial in the grave not leaving enough room. Mm-hmm. Most of these occur the day of the funeral burial, since the parish cemetery has the grave digger dig the day of the funeral, since they do not want to have an open grave overnight. Mm-hmm. I took care of the errors in all cases at no charge. Am I still liable even though I had no control over the parish religious decision?
So it's interesting, because off the bat, a funeral home would not incur liability for the, normally, if you sue a cemetery, they could always try to indemnify a funeral home to say, well, this was called in incorrectly, they gave the wrong dimensions of the casket size. So the cemetery can always indemnify a funeral home, but if a family has a cause of action against the cemetery, that in and of itself doesn't automatically create a funeral home liability. So I think the question is, once you help the cemetery fix their errors, you can expose yourself to liability that way. So what I would do is obviously it sounds like a problem that definitely needs to be addressed. I would notify the board of that cemetery, the board of the parish, put something in writing of your concerns and the the frequency of which they're arising, have documentation of each family, each date, each time, and each problem, and seek, to get assistance from the top down, that the board really takes action to either employ more grave diggers or have an oversight committee. In my funeral home, we have two funeral homes in Connecticut, and I run into a similar problem. Although it's a much larger cemetery, you wouldn't think that would happen, but the issues are always identified in advance of the day of the funeral. So again, just by helping the cemetery, you can expose yourself to liability for doing that. So even though you're doing the right thing and trying to be the good guy, you can expose yourself to liability for getting involved that way. But in general, if the family was making a claim against the cemetery, that would be a claim exclusive to the cemetery that I would not foresee incurring funeral home liability. But again, if a family is making a claim against a cemetery, they always have the option to try to indemnify the funeral home and blame it on us that, again, it wasn't called in properly, etc. So my advice on that is to put some type of formal complaint in writing to the board, to a larger oversight. There has to be somebody overseeing that cemetery, and I would certainly look to do that because it sounds like a nightmare for you.
Great, thank you. And one more came in.
Sure.
Can you go to the county bar to get a status on an estate when the attorney will not respond?
Probate proceedings, so it wouldn't be the county bar, it would be the probate court. And I do believe those should be matters of public record. So you could certainly see a case online on a docket. They're not normally sealed records, but you could always, I'm assuming this is a matter of an estate that's taken a while to settle and the funeral home remains unpaid. That should be something that you could investigate with the surrogates court.
Great, and then that's it for now. So thanks so much, Jen.
No problem. Okay, so let's get back to loss of sepulcher. And how do we protect ourselves? It all comes down to good faith in dealing with families, guys. Due diligence to ascertain if you have the proper next of kin. That's a big one. And let's talk about, we've all had this situation where, we have successive marriages. We have the stepkids that, the kids that hate their step parent. We have the people who come to the table and they forget to tell you, oh, by the way, dad was married. So we have to do proper due diligence. If we carry out instructions in an agent letter or other instrument, we'll always be protected. But we don't always have an agent letter. An at-need agent letter is a wonderful thing because then that next of kin we're shifting the onus on them to say they're the ones making the representation that they are the proper legal party to be making this arrangement, and the funeral home, by working for them, is acting in good faith. We are protected by good faith in dealing. I'll get to that in the end. But part of that due diligence is to really go above and beyond when in doubt. So what I always do if I'm in that situation, and it happens often, these are not far-fetched things, I always try to get something in writing. So let's say that there's an estranged spouse, but they're still married or they're separated. Legal separation is still marriage. That's still recognized as a valid marriage. When in doubt, get something in writing. I try to get that estranged spouse to email the funeral home, to put a letter, to do something stating that they are authorizing this other party to come in to make arrangements. It's a simple step, but you print that out, you put that in your file, and you can show as a funeral home that you've done your due diligence. So, when it sounds shady, probe a little bit. But we're protected for doing the right thing. There's statutory protection for us. There's a great emphasis on making sure we are dealing with the proper party and true next of kin. And once again, when in doubt, the at-need agent letter. Shift the onus on them, really, to let them say that they're the ones taking responsibility and they're legally allowed to do so. Other ways that we can incur lawsuits in the funeral business, there's fraud, there's breach of contract, and there's, of course, theft. And like I said, claims like these can arise from doing our normal course of business. These are not things that, can happen, these far-fetched things that can happen. And bear with me one moment. I'm just going to plug into my supply here, Kelly. Just a little battery drain. Bear with me 1 second.
Go ahead, no problem.
We're good to go. We've had a couple of technical difficulties today, Kelly, haven't we?
We sure have.
Okay. So as I was saying, claims like these, they can arise from our normal course of business. These are things that just can happen every day when we're turning our key into the door. So let's talk about them. How can a family claim negligent infliction of emotional distress? Okay, let's talk about embalming. So families can claim that the appearance of their loved one caused them emotional distress. How do they prove this? They can have photos taken of the deceased. If there's a lawsuit, we're going to have depositions. We're going to have discovery. So how do we protect ourselves? Well, first of all, being thorough with the family in the arrangement process, it's always a good thing. Proper embalming explanations, what embalming actually does. Embalming is not a foolproof procedure. It's a method of preservation. Nowadays, we have a lot of delayed embalming situations where someone passes and the family's waiting 3 or 4 weeks because they don't want to cancel that vacation, or the little grandson has a baseball tournament in 2 weeks. I mean, again, I don't have to tell you. You guys know this is real. This happens. So proper embalming authorizations. I actually have something in writing where I let a family know if there is a situation where they're looking for embalming, through a viewing about 3 weeks out, to let them know that there are some, potential changes or alterations to condition that can happen. It's just the normal bodily processes, normal decomposition. There's a way to word it very discreetly, and it's not anything egregious to put in writing, but you want the family to be aware, again, that embalming, it's not a foolproof procedure. We also want to let a family know, let's be upfront and be honest. If we have a really bad case, if there is a bad body, quote unquote, a really bad manner of death, we want the family to be aware of the potential viewability issues. So be upfront, be honest. That's always going to get you far. Document conversations that you have with families. Keep really good notes. Notes that you're creating in the moment are extemporaneous notes, so you're not going back and relying on your memory. You can show the court, if it comes to that they're written in real time. Those are really, really good parts of your defense. So have these conversations with families where you explain if the deceased is in a potentially non-viewable condition. All of these things we can do to protect ourselves to, minimize the potential of a cause of action. Other ways they can, I've seen just from doing some research, condition of the funeral home. If you have a funeral home with flies all around, foul odors, that's a potential claim. If a family brings clothing that gets mixed up with another decedent, that's even a potential claim. These are just some examples, although they seem silly or frivolous, examples of what can spark a family to contact an attorney and commence an action. And again, as I hope you'll see for yourself, if attorneys are advertising, was your loved one mistreated, or were you emotionally disturbed following the funeral of a loved one? Those attorneys are out there. And I speak freely as the funeral director, as an attorney, and I'm much more proud of the funeral director title for sure. So just be aware. So COVID, we can do a whole separate CEU on this, and I'm not going to say much now, but how can we face a potential liability for COVID? And attorneys have already begun to plant the seed. Funeral homes that had refrigerated trucks on site for body storage. The actual legal term that's been coined is corpse mistreatment. This has gained local and national attention. I don't know if you guys remember, the New York Post put that article right in the height of COVID of a refrigerated truck. But corpse mistreatment, this one can possibly fall under the intentional infliction of emotional distress if it's something that would be deemed to shock the system. So again, how do we protect ourselves against this? COVID's over, COVID's done. But let's be honest, for some, it's become a revenue stream. I'm sure you still have families looking for COVID on a death certificate so they can get that unlimited pool of government money that seems to keep coming in. Now, this is another potential avenue for families. And I'm not minimizing anybody who did suffer a COVID loss. COVID was real. No one saw COVID through the lenses of a funeral director for sure. But again, being in a litigious society, this is something that can arise. How do we protect ourselves? My advice, go back through your files during COVID. Do some administrative housekeeping when you have a slow day at the funeral home. Look for documents of body tracking, evidence of the decedent locations, receipts for the crematories, keeping in mind we weren't always using our local crematories. This is going to be a proper record-keeping thing. That's going to be what exculpates the funeral home from liability. Proper record keeping, dotting I's, crossing T's. But it's really a good idea to go back through those files, make sure you have notes of if you did have a deceased in a refrigerated truck, that there was some documentation of where they were, when they were taken from the hospital, when they were brought to final disposition. Clean those files up, and that certainly would help you in the event that a claim arose from that. Moving forward, how do they prove loss of sepulcher? How would a family prove that? Again, the proper next of kin issue, dealing with someone other than the next of kin can cause this claim. We mentioned successive marriages, even children at odds. So if you have 4 kids, you'll have 5 different opinions, and then it becomes an issue of who's the proper party. I know our laws changed on that recently to be a majority rule. If a majority of the kids were in agreement, the funeral director and the funeral home were protected. Again, it becomes a dotting I's, crossing T's issue. I would definitely look to get, if there's a child not part of the arrangement process, it never hurts to get an email where they're giving preference to their siblings to carry out arrangements. But going back to sepulcher, any error on part of the funeral home or director that causes delay, hardship, or adversely impacts proper disposition being effectively carried out can fall under this. And again, wrong grave opening can fall under that as well. Going back to that cemetery question, that would certainly be a loss of sepulcher claim if that casket couldn't properly get into that grave. How do you prove fraud? So, moving forward, this is a big one, guys. I know full well there is a license shortage out there. Again, that's a conversation for another day. However, making arrangements with an unlicensed funeral director is an automatic case of fraud. Anything that goes wrong in that funeral from the moment they've met with that unlicensed director, it really invalidates the contract. If any legal issues arise, this is an outright fraud, an outright fault on the part of the funeral home. An unlicensed director is prima facie evidence for fraud. What is prima facie? It means the evidence in and of itself speaks to the crime, so to speak, or the liability. So you might think that they can't prove this. Not true. Because even if they're suing you for something else that has nothing to do with the arrangement, there's going to be a deposition. There's going to be a discovery. And in that deposition, they're going to say, well, who did you meet with? And they could be describing, a man, but it was a woman's signature on the contract as the licensed funeral director. It's going to come out, trust me, and it's going to create huge implications down the road. Other fraud charges that don't match up to GPL, overcharging, failure to disclose all casket options, all outer burial options, charging for refrigeration when you don't have refrigeration. Again, these would be breach of contract as well, but they could also fall under fraudulent claims. They often work in concert, fraud and breach in contract. So if your funeral home doesn't provide exactly what's on that contract, you can be sued for breach of contract. And again, unlicensed directors using pre-signed itemizations, prima facie evidence for fraud and breach of contract. So let's protect ourselves there. Theft, this is another one. Again, families can claim theft of decedent's jewelry. How do we protect ourselves? Log in everything we receive in a very detailed fashion. Also, make the family sign off when they receive the jewelry back. It's very easy sometimes just to gently hand, that velvet jewelry pouch back into the next of kin's hand the morning of a funeral. get them to sign it. Find a better way to have that transfer of tangible items back to the family. There could be potential criminal liabilities here as well, but it's negative PR, and we always want to protect against that. So if you receive a decedent into your care, especially if you're using a trade outfit, make sure from the minute that decedent's in your care, you're logging exactly what they have. Tell the family right away, there's a necklace on mom, there's a watch on dad. This all comes down to dotting I's and crossing T's. Some other areas of liability, cremation, as we know. Again, we need to obtain proper authorizations, returning ashes. Follow the designation of intent form. What I do in a case where, either mom might pick up the ashes or one of the kids, I put on the return section, I'll list multiple names of people who can pick up the remains. Dividing remains. I make a family sign off if they want to divide ashes into different receptacles. Commingling remains. Identification of deceased prior to cremation, always an advisable thing for your funeral home. Again, how can we protect, dot our I's, cross our T's, make sure our forms are properly filled out, just always doing the right thing. So cheer up, guys, because I know we talked about a lot of doom and gloom and worst case scenarios today, but it's not all bad. New York recognized an implied good faith covenant and fair dealing. So here's what that means. It means if there's an implication that neither party is attempting to do anything injurious to the other. However, this obviously can be disproved if the family has evidence that the funeral home did something wrong. But New York does have an implied good faith covenant. It goes back to, like I said earlier, with those next of kin issues. If you're doing your due diligence to ascertain if you're sitting with the proper party and the party's going to sign that at-need agent letter, you did your due diligence by making them sign that. If there was a spouse that was estranged and you're aware of that spouse and you're making attempts to locate the spouse or get the spouse to send an email, you're doing your due diligence. If you're explaining to a family that viewability is probably not likely in a certain case because of how they passed away, and you document that conversation, you're doing that due diligence. Again, when in doubt, get it in writing. Don't make arrangements if you're not licensed. It also devalues our profession as a whole. Be careful with jewelry. Log in, log out. Follow your GPL. Be honest. Do the right thing. And that should be the moral of the story. But we have a responsibility to our families, but also to ourselves, our firms, and our colleagues. One bad act of a funeral home has a ripple effect on everyone. And guys, just be mindful of the new era that we live in, again, where people are litigious. People always have cell phones out. They can record anything. They can share on social media. And lawyers are always looking for, quote, unquote, new victims to represent. So with that, I think we covered a lot of different ways that we're exposed to liability and how we can protect ourselves. And I hope you take at least some of this information back with you. I know that you're all out there doing your best every day, working extremely hard, probably underappreciated for what you do, but I know it's rewarding work and it can sometimes be a little thankless as well. But we hope today that you took something away to learn that being aware can certainly go a long way.
Thank you so much, Jen. This was an amazing webinar. But I do have a few last-minute questions if you have time for some.
Absolutely.
Okay. Is there some type of waiver form that can be used for delayed embalming situations?
So it's funny. That was like my original conversation with Mike, why I reached out, because I wanted to see that. I wanted to get something up on the website. I've created one. I'm happy to send it over to you, Kelly, for you guys to take a look at, and if you think it's worth implementing or sending it over. But basically, it just describes, embalming is for preservation. It doesn't get very technical, but we, in the form, we just discussed advising a family when possible not to delay, and how there's no quantitative measure of time that will say when embalming won't be effective or when the deceased isn't going to look their best. Obviously, the nature of death, the manner of death, and all those other circumstances and factors come into play. But some general disclaimer where the funeral home represents that they can't make any assertions as to how the deceased will look at that certain time, and the family's acknowledging it. An in-house document, I think, would be great. And like I said, Kelly, I'm happy to share something that I was just playing around with myself for you to look at, show it to Mike, and then you guys can send it out to whomever's requesting.
Great. Thank you. We'd appreciate that.
Okay.
Regarding the customer's designation of intention, when sending cremains to family via USPS Express Mail, what is the best practice for receipt portion? I keep the USPS receipt with tracking. Sometimes people won't respond to requests to sign off on emailed receipt.
I think but as long as you have the email chain where you're trying to notify the family and you have tracking numbers on it, I think you're fine. We use, obviously we all have to send through the postal service, but I think any documentation where you show that you have a tracking number and if the post office is reporting it received and you're trying to reach out to a family, you've done your part at that point, regardless if they've responded back to you.
What are your thoughts on crematories allowing families to witness the cremation of their loved one?
Is this a push button service they're asking about?
Yes.
Okay. I mean, I know the crematory that we use, I'm in southern Westchester, obviously. The families have to sign off on that. I just had one recently, and I believe that that's the case. What my thoughts are always, the attorney in me is always going to say, if they've waived liability on a signed paper, I think you're fine. The way they do it down in Ferncliff is they're not witnessing the whole process. They're pushing that button, and they usually walk out of that room. They allow up to, I'm trying to think. There was 2 people allowed last time to come in and do that, and it's fairly recent. My thoughts are if you have a waiver of liability that the family is signing, that they understand what they're doing, they're going to hold the crematory harmless. And again, I think that's a document generated from the crematory. But I think, again, if I's dotted, T's are crossed, if that's their preference, for something like that, it's a religious preference. I certainly understand it. It wouldn't be, the funeral director and me wouldn't want to see that on every cremation for sure. But it all comes down to waivers and waiving liability and protecting yourself.
Speaking of protecting themselves, should a crematory be named as an additional insured by the funeral home?
That's interesting. Conversely, the crematories don't name the funeral homes as additionally insured with the rider. That's very interesting. That's something I'd like to look in and be able to answer it more intelligently. It's a very amazing point. I will get back to you on that. I'd like to learn more about it myself.
Great. Are there any risks to posting obituaries on social media?
So it's interesting because I'm sure my colleagues on the line today have all had that one crazy family that says, I don't want it on there. And nowadays you have the issue where there's third-party websites that extract the obituary off your website and post it. And, I've gotten a couple of hysterical phone calls at ungodly hours about that as well. So my thoughts are, if you have an arrangement conference with the family, you have to discuss obituaries. I always tell a family, an obituary will automatically appear on my website unless I am instructed otherwise. But once it appears on my website, I always say, it goes through Facebook and social media. It's certainly worth having that discussion in the arrangement conference to ascertain if they have any reservations about that, because when in doubt, don't post it at all. And again, third parties can certainly access that and then repost without your permission. So definitely make that a part of your arrangement conference to discuss publishing obituaries.
Okay. During the arrangement, should the consumer receive a copy of everything that they have signed?
I always do that, yes. I mean, they have to receive a copy of the itemization. We know that. I still use I'm still the dinosaur. I don't like to use the computer generated copy, so I still give the yellow copy. But I do that. But that's not required to do. I know in Connecticut the laws are much different. I have to keep copies on file of documents, but if it's something such as if it's a crematory, the New York State authorization, no, I wouldn't think that. But if you do have a family signing a delayed embalming waiver or instructions regarding dividing ashes, I have a little form I made for that. If it's something like that, I would definitely give them a copy and keep one yourself.
Can a funeral home refuse service when the authorization appears to be untrue?
Meaning if they don't believe it's the proper next of kin?
Yes.
That's interesting, but legally I probably would say yes. But they have to prove if they ever got. So again, it all comes down to what you can do and what you can get sued for. I mean, what is the likelihood that family that you refuse is going to go out, hire a lawyer, and sue you for not taking their funeral? Because how would you measure the damages in that? They obviously have to go to a funeral home. But if it ever came down to a lawsuit, you would have to have documented reasons as to why you were not accepting their representation as them being next of kin.
Right, and we always say that the cremation authorization should be remotely witnessed. So that's another way to protect yourself.
And always, again, it all comes down to documenting. If something is not looking right, if you have an uneasy feeling, writing notes in the moment will always help you down the road if you find yourself involved in some type of action.
Right. Document.
Yep.
And the last one is more of a comment. When listing items such as jewelry, do not use a description such as gold, silver, etc. Use a description such as gold-colored metal or silver-colored metal.
I even say like yellow-color metal or gray-color metal too. Absolutely. Like don't say diamond, say clear stone, right?
Yeah.
Yeah. Very, very true. But again, it's the logging in definitely, but the logging out, that's the big one, because it's just, it's so innocent in nature. You take mom's earrings off, you put it in your nice little pouch, and you go to hand it back to a family, and you're just gently placing it in their hand like a handshake. But as kind as the gesture is, you really need to find a way to document that they signed off that they've received it back. And I always go over, in the arrangements, I discuss what we're doing with jewelry. I go back over all of it again the morning of the funeral. And I tell the family that not to worry, we're going to have this discussion again on the day of the funeral, because you want to make sure they haven't changed their opinion about what jewelry is coming back or whatnot. And you want to make sure you're relisting the items that are being taken off. And it is probably better to hand that to them as soon as possible. When leaving the funeral home, but get something in writing where they've signed that they have it.
And one last question that did pop up. Can you just refuse a service if your gut is telling you this is trouble?
I mean, that's an ethical question. I mean, listen, I've been there. It's hard to say because of, there's no automatic right to be able to go to a funeral home, but there is a right of sepulcher. So there is an automatic right to have your loved one buried in a proper, timely fashion. So the type of suit that you could get from that would be a loss of sepulcher claim. But, it comes down to, listen, I am a big trust your gut person, but if you're going to do that, have documented reasons. There are ways to do it. It's a tough call, and there's no black or white on that. There's no outright legal answer I can give you, but trust your gut, but document why. And again, the only type of claim I could probably see for that would be a loss of sepulcher if their right to to burial in a timely fashion was impacted by that.
And as we finish up, can you just remind us how long the documents need to be retained in case you do get sued?
Well, again, the tort, so it's 3 years for tort in New York, 6 years breach of contract. But Kelly, you can back me up on this. I think, is it 7 years we have to hold on to our stuff? I don't know.
Yeah,
I have papers in my funeral home that predate my existence on this earth. So, you know, I know in a lot of days now too, there's this, you know, move to digitalize everything. So that's the way that we can kind of keep our records in perpetuity by transferring to digital files. But I do believe 7 years. I do believe 7 years for a file. Itemizations, you know, we always keep the pink sheets. Those have to go back. I want to say 7 is the number that's popping out of my mind. But Kelly, maybe you can bring clarification from the state on that.
Yeah, I will look back up in the information and just make sure that it's accurate. But I believe that is it. But I will look. I think it's different times for certain things.
Right. Okay. Yeah. Itemization. Yep. Mhm.
And I know we're getting past the time, but one did come in. Let's say a spouse gives up control, but later says they want back a lock of hair. Should the person in control sign a document regarding this?
I would. It's something seemingly simple. You know, again, if it was ever if you didn't have the document and the person in control found out about the lock of hair, I don't think they have a valid claim. I mean, how could you really claim emotional distress on that? But if it's a situation where you're seeing adverse parties, it's not going to hurt to have that. I don't think it's going to be necessary either. And the alternative, if you didn't have it, I don't think you'd be, you know, I don't think you'd be impacted in the absence of a document. But again, anytime you see feuding parties, get things in writing.
Well, Jen, thank you so much for an amazing webinar. The comments are coming in. Thank you so much. This is the best webinar. Everything.
Yeah. Oh, thanks,
so
guys. And
really,
thank you for the opportunity to do this. You know, I'm a funeral director at heart. It's my life's work. So I want to see us all succeed. And I want to elevate the industry, as well as, you know, the way people view the industry from the outside. But we have to stick together. And I was so happy to do this. So thank you again, Kelly. I appreciate it.
Thank you. And just a reminder to everyone, please allow 7 to 10 business days to receive your credit. Again, if you've had any technical issues during this webinar, please reach out to us immediately. We will be unable to take any excuses or technical difficulties a week from now. And thank you so much for attending, and have a great afternoon, everyone. Take care.
Thanks, guys. Have a great summer. Bye-bye.